Directory provisions are non-mandatory clauses or instructions or guidelines within a statute. They guide or recommend certain actions, but non-compliance with these directory provisions does not automatically invalidate the actions or the proceedings that they relate to. Directory provisions often use the words may or recommend. One way of identifying whether a provision is directory or mandatory is to see what is the effect of the non-compliance. If there are no penalties or liabilities or negative repercussions due to non-compliance, then it is a directory statute. Otherwise, it is mandatory. This test was also reconfirmed by the court in a landmark 1994 case. While interpreting a directory statute, the context and the purpose of the statute must also be taken into consideration. And if the statute is directory, then an approach of substantial compliance can also be used, which means that if a person has made a reasonable effort to comply with the provisions, that can be considered sufficient, even if the compliance is not 100%. This point was also reiterated in a 1955 case that non-compliance with a directory provision should not lead to an adverse impact unless a prejudice is caused to the other party. Which means that even substantial compliance is okay as long as there is no real harm that is caused by the partial compliance. And the court can also take into consideration whether strict compliance with the provisions or lenient compliance best meets the tests of reasonableness and best serves public interest. And as with any statute, any interpretation must be validated against the presumptions as to the interpretation of statutes.